Court will call a matter of State versus Morgan E. Geyser, case number 14 CF 596, appearances.
The State by Ted Sapakowicz and Abby Nikolai.
Thank you and good morning.
Good morning. Morgan Geyser is here in person with Donna Kukler from Kukler and Cotton.
All right, thank you and good morning. Court's here today to review the proposed plan of release that was submitted on April 14, 2025. Has the state received it?
Yes.
Has the defense received it?
Yes.
Has the defense had an opportunity to review the report with Ms. Geyser?
Yes, we have.
I note that the court had previously submitted an order that authorized that Ms. Geyser be approved a supervised release for her under the statute, and the state ultimately prepares the plan that's been submitted. The petition for supervised release was under section 971.17 sub 4 of the statutes. And then under sub 4 sub E, it sets forth the basis for the plan that's to be submitted to the court. It's been submitted to the court, and now we're here on a hearing with regard to that. Sub E sets forth various items and criteria that addresses the content of the report. I've read the report as well. Further, I had submitted to Ms. Trinkner, the drafter of the report, some questions. She responded to those questions by email that was submitted on April 23 and placed in the file. Has the state had an opportunity to see that?
I've seen that, yes, Judge.
All right. Defense had an opportunity to see that as well?
Yes, Judge.
All right. And is Ms. Trinkner in court today?
She is.
All right. Where is she? There we go. All right. Thank you. So what's the state's view?
Judge, my view is we have a large problem. And I don't mean to speak for Ms. Trinkner, but I believe they would like an opportunity to redo this plan. When I first read the plan, Judge, I was shocked that there was no mention whatsoever of the victim or where the victim might reside or where this proposed residence for Ms. Geyser was in relation to where the victim resided. The authors of the plan never consulted with the victim in this case, and I have learned in the last 5 or 10 minutes that literally these two locations, the victim's residence and this proposed location for Ms. Geyser, are in less than 8 miles from each other. The entire state of Wisconsin, Judge, we have a plan that has her 8 miles away. The department and the authors of the plan didn't know that. They don't believe it's at all appropriate anymore. The victims are here by Zoom, and I know victim's mom wished to address the court. We knew generally that they were very close by, and now, like I said, in the last 10 minutes, I've been provided the exact address of where Ms. Geyser is proposed to be, and literally less than 8 miles apart, Judge. So we object to the plan. We're asking that the court adjourn this hearing and give the authors of the plan more time to see if there isn't somewhere else that may be more appropriate under the circumstances.
All right, thank you. Ms. Thickner, could you come forward and just have a seat at the table in front? She should be able to sit at the front table. Then just identify yourself, please.
Yep. Grace, Grace, Trinkner, Trinkner.
And what role do you have in this matter?
Yep, I am the case manager assigned to Morgan Geyser.
All right. And you prepared the supervised release plan.
Yes, I did.
All right. So what's the status of the plan from your perspective?
At this time, we would ask for more time to look for a new location for Ms. Geyser to reside. Originally, we felt it was appropriate for Ms. Geyser to reside in Milwaukee County, as we believed it was removing her from the location that the offense occurred. At this time, now that we know that the location is close to the victim's residence, we no longer feel it is appropriate for Ms. Geyser to reside there.
All right. Just on the status of 8 miles, what distance do you believe would be appropriate to separate the victim from Ms. Geyser?
I don't know at this time.
Well, are you looking at 8.5 miles? Are you looking at 10 miles, 20
We're
miles, 50?
We're definitely looking at more than 10 miles.
All right. Would that be outside of the, you've made a determination that placement would be outside of Waukesha County.
Yes.
So you're looking perhaps at a location outside of Milwaukee County as well?
If it is appropriate, yes.
All right. What's the defense position then?
This is first we're hearing about it.
Yeah, I'm sort of surprised there wasn't a discussion about that
Same
before
here.
the case is called. It's usually a professional courtesy that's extended just to clear the air and be able to go forward. So what's the...
I didn't have a chance to formulate, my thoughts exactly, but I don't know when we say 8 miles, if they're in the same county. Is that what, I haven't heard that the victim is living in Milwaukee County. Is that what I understand?
Well, Judge,
Now, nobody asked for you to respond yet. And Attorney Kukler, you can't address questions to others than the court.
I'm addressing it to Your Honor.
All right.
My question would be whether or not they're both living in the same county. 8 miles could be, you could be in Waukesha County, Jefferson County. You could, couldn't be Jefferson for 8. But I don't think 8 miles just per se is a problem. I would also point out that there is a no contact that's part of the plan, of course. So to suggest that there's been no consideration of the victim isn't true, because that is part of the plan, that Morgan have no contact with her. I would also point out that the plan provides for Morgan to be on house arrest. She's not allowed to leave where she's going to be placed. And I think that what we could do is allow her to be placed where the place has been provided for her. She'll be on house arrest, and if the state wants to work on finding yet another place to move her to, then they could move her when they find that other place, but she can't leave where she's going to be residing anyway. So that would be my thought.
All right. Ms. Thickner, apparently up until this morning, you had not, I was going to say proximity, but I don't see that 8 miles is in proximity to the victim. It's less than 10 miles, I understand that. But what was the criteria that the state used in developing the recommendation that it did?
The recommendation of the housing?
Right, well, the plan.
Yeah. Well, we consulted with Department of Corrections and Department of Health Services to develop the plan. We met several times to go over different restrictions that we felt might be appropriate for Ms. Geyser, based on the offense itself, based on her current treatment needs. And we determined that a group home would be appropriate for her at this time, as there would be increased supervision, as well as GPS monitoring, so that Ms. Geyser's location could be tracked and different areas would be restricted.
So what is the district attorney reported, and you've reported, and what you've said is that based upon the 8-mile distance between the victim and the group home, that is inappropriate. Why? I guess I'm somewhat struggling with why it's inappropriate.
We would like there to be distance between Ms. Geyser and the victim due to the victim's safety and providing the victim space to continue to reside where they are without worrying about Ms. Geyser's location.
All right, any response from Attorney Kukler?
Well, again, I am just wondering if they're within the same county or not.
Well, that apparently the view of the conditional release writer is that there be greater distance between the victim and Ms. Geyser's residence.
Ms. Geyser isn't allowed to leave her county.
Now, I understand that concept. I also understand the argument that's being made as a justification for a renewed report. It may be that Milwaukee County, if Milwaukee County is a location, is a big county. It may be that they'd look elsewhere. It certainly is a factor that I'm satisfied that it's appropriate to review. In other respects, I'm satisfied the report is appropriate. What's the state's view with regard to the report, other than the distance?
There are some things, Judge, that were left open-ended, like GPS restrictions, and much of what's indicated in the report is left to the discretion of the treatment team. We think there should be some further judicial oversight on some of these factors, like location, like GPS restrictions. Like those things can't get moved without notice to the court, and the court can decide whether it wants to have a hearing or not, but at least that notice be provided, and perhaps the court would decide this is something the court should take a look at, and it should be the judge's decision when some of these changes to the plan get made. Back on the living situation, Judge, I thought there was some effort here to keep both locations confidential. In fact, that's why the location for Ms. Geyser was submitted in camera to the court this morning, I believe. So on the issue,
Well, we have nothing. By the way, I have nothing that was submitted to the court this morning.
it may be that Ms. Trinkner has it with her. I'm not sure if that. I assume that's been submitted to the court, but.
Jessica, have we received anything?
I don't see anything.
Maybe Ms. Trinkner can speak to that, Judge, but it does have the exact address, and we were just provided with that this morning. Also, Judge.
Oh, wait now.
Okay.
I don't have, you said I had it. I don't have it. And I'm looking now at Ms. Thickner to see, do I have it and it's just not been transmitted electronically, or what happened?
It has not been submitted electronically. Our contractors at DHS wanted us to provide a paper copy today at the court hearing, and it was provided this morning to Attorney Nikolai.
Was it provided to the defense?
No.
We brought along a singular copy. We were told it was to be reviewed in the judge's chambers.
Of course, then you give it to the DA. You don't give it to the judge.
I apologize.
It's an odd way to operate.
And I thought it was provided to the court, Judge.
And not provided to the defense. That's not appropriate at all.
I do apologize.
Now, this is what some people may refer to as a high-profile case, which would generally mean that in particular T's are crossed, I's are dotted, to be sure that all rights are protected and that notice is appropriately given. It's not meant to be a subterfuge or somewhat trickery involved or ambush type of thing with new issues being raised at the last minute and other people involved don't know about it, and that's somewhat what's happened here. I'm really surprised. If I need another comment, I'll ask for it. I'm just reviewing the report. All right, the victim's mother wanted to make a statement.
She does, Judge.
All right. And just identify the victim's mother.
Stacy Lautner, and she's appearing by Zoom.
So, Ms. Lautner, are you present by Zoom?
Good morning, Your Honor. Yes, I am.
You wish to make a statement, you may.
I do. Thank you. Good morning, Your Honor. My name is Stacy Leitner, and I am the mother of Peyton Leitner. I speak today on behalf of our entire family regarding the proposed conditional release of Ms. Geyser. Last week, we reviewed aspects of Ms. Geyser's release plan with the District Attorney's Office and were immediately and deeply concerned to learn the proposed community for her placement. This community is the same community where Peyton currently resides, pursues her graduate studies, maintains her social connections with friends and family, and works as a mental health provider. As Your Honor can appreciate, this news has caused significant distress for our family. This is not the first experience with the conditional release process. In spring of 2021, Ms. Geyser's co-defendant was released. During that process, the conditional release team engaged with our family to understand Peyton's residence and schooling. The resulting release plan considered these factors, offering us a measure of reassurance that the efforts were made to ensure Peyton's safety. In stark contrast, the Department of Health Services made no attempt to contact our family while drafting Ms. Geyser's release plan. They made no effort to ascertain details of Peyton's daily life that would be pertinent to this planning. While we understand the complexities of this case and the need to consider Ms. Geyser's safety given the public and media attention, we must ask, what consideration has been given to Peyton's rights and her need for safety? It is difficult for us to comprehend why, in this instance, the rights of the offender appear to supersede the rights of the victim. Peyton has worked incredibly hard to heal from the profound trauma she endured and has established a meaningful life within this community. She deserves the fundamental right to continue living her life in peace. She deserves the right to engage in everyday activities, such as grocery shopping or visiting the library, without the agonizing fear of encountering the individual who held her down and stabbed her 19 times when she was just 12 years old. It feels unconscionable that the Department of Health Services seemingly failed to consider the profound re-traumatization these actions could inflict upon Peyton. Therefore, Your Honor, we respectfully request that you order the conditional release planning team to identify alternative placement facilities for Ms. Geyser in a community where Peyton can continue to live her life without this constant and understandable fear. Thank you for your time and careful consideration of our concerns.
All right, thank you. I appreciate you being here and appearing and your statement as well. Any further statements from the district attorney?
Judge, I can't put it any better than that. That is the concern, and that's why we're asking that you reject this plan today and allow more time for a different possible placement. Like I said, we didn't learn until moments before the hearing how exactly close the two placements were. There had been an email from Ms. Erin Groff to the defense and to the state indicating the department's plan was to provide a written notice of Ms. Geyser's proposed address for an in-camera review, as again, these locations, everyone's doing their best to try to keep it confidential.
All right, again, it's always amazing. An in-camera review would have been with the court, and the court's not part of the communication. That's an interesting way to operate. Not the DA's responsibility, but interesting how the state operates, how the planning operates. And I'll look to Attorney Kugler. Anything further from Attorney Kugler?
I understand the concern here. I didn't realize that there was a discussion last week about the victim's family's concern. Wish that had been brought to our attention. We could have potentially talked to Department of Health Services and maybe made some headway on that before coming here today. I again ask that in the interim that you allow Ms. Geyser to reside at the group home under the restriction of being remaining in the home while the state looks for a different placement for her if you think that's appropriate.
All right, thank you. Well, I read the report, the conditional release plan, before coming to court, and I took some time now just to review it once again. Ms. Thickner, anything further from you?
No, Your Honor.
If I do order that there be an amended plan submitted with regard to placement locations, what is your time frame?
We would need at least 30 days.
All right. To do the amendment. All right.
Correct.
All right. Well, I'm satisfied that the issue of location is an important matter. Proximity maybe isn't well, it could be a good description, but location of the defendant's placement, location of the victim are significant factors. There are no contact orders as part of the plan. There's monitoring as part of the plan. All those are significant. What happens, even in the best of circumstances, is that oftentimes there's inadvertent contact that occurs, not meant to happen, but it happens. The closer people are to each other, the more likely inadvertent contact, the more likely that type of inadvertent contact can occur. We don't want that to happen in any type of case, certainly in this case with regard to the particular history of it. So that's a significant factor for the court to consider. The court presided over the earlier conditional release plan of the co-defendant, and I recall the carefulness with regard to the contact with the victims and victim's family, and the defense at that point to be sure that all was proper and appropriate. There seemed to be some. Well, there's some. I don't know. I don't quite know how to describe it, but I'm disappointed in the states in the plan, in the conditional release team, in how they've appropriated and how they came up with the plan, not taking into account the location, but then this type of really communication with only one side of the situation, and then that they communicate with regard to things the court should do without letting the court in. It's a secret, and unfortunately, the court can't be secret from the court, and it wasn't until this morning, and when it's brought up in the court on a number of occasions. So that's I'm hoping that'll be rectified. So I'm going to order that the conditional release plan submit an updated report that addresses location. And I think the state's comment with regard to the GPS monitoring, the type of any travel outside of restricted areas should be subject to at least court review, and that should be part of the hearing. With regard to the co-defendant, when there was a petition filed to eliminate the GPS monitoring, and that was then held in court. We conducted a hearing on it, and I think that's appropriate for those type of situations to occur as well. So I'll order that the plan be modified in all material respects to take into account the location of the defendant relative to the victim, that court supervision of any changes to one of the substantial factors, such as GPS monitoring, be set forth so it can be reviewed by the court, and that any other material aspects of the report which should be modified can be modified at that point. I'm going to order that any additions and modifications be completed within 30 days of today's date. That today is April 28th. So if you file it by May 28th, can you do that?
Yes, I can.
All right. And then we'll set a hearing then in June, probably the mid-June, with regard to that. And I allow 2 hours.
I'll grab my calendar just a second.
As part of looking for the date, I want to be sure that any material aspects of the report, communications of the report, have to be communicated to both parties, both the defense and the state. This isn't the conditional release team is not an agent of the district attorney's office. You're actually probably an agent of the court, if nothing, as I appointed you and requested that you do the report. That means you have to communicate with both the defense and the state, and where the court's particularly involved, the court should be told and communicated with as well. The court should not be in a position to learn about things the court should know from one of the attorneys in the case because they had a conversation with the conditional release team.
June 20th at 9:30?
Do you need another date, Attorney Kukler?
Yes.
All right, we'll give you another date. That week or another week?
Are we going to be looking later?
We're looking for a date.
Okay. Would you have anything the week of June, like June 9th or June 10th, possibly?
Could do June 9th at 8:30.
Thank you.
Good for you then?
Good. Thank you.
Good for the state?
It's good for us, Judge. We would need some confirmation, if possible, from the victims if that date's available.
Do you have, how do you want to have that confirmed? We'll do it just on the
If Ms.
Zoom
Leitner-
appearance.
If
Ms.
she-
Leitner, are you there again?
I am Judge.
Is that a good date for you?
Was the date June 9th?
Yes.
June 9th at 8:30.
Yes, that date works for me.
All right, very good. Anybody else have a significant issue with that date that we ought to know about? No.
I think that's good, Judge.
Of that, then in looking at the case, the conditional release port, in other respects, from the court standpoint, is appropriate and fair and reasonable to all parties involved, the state, the public, as well as the defendant. The defense suggested that pending a modification of the report, that Ms. Geyser be permitted to be placed at the location that has been suggested by the state, which is part of this closeness issue. Well, on the one hand, that on first blush could appear, well, it's reasonable, we'll make the transition, and then another transition at some later date. On the other hand, and I'm more satisfied with the court should maintain stability in a case such as this, and that before the court approves any moves, any plans, that all should be in order. That there's nothing hanging out there that has to be adjusted down the line. Sometimes adjustments down the line on one part can have a big impact on other parts of it. So under those circumstances, then it's important that when the court reviews the plan and approves the plan, that it be the plan, and that it cover all bases that's appropriate. So on that basis, I'm satisfied that I'm going to order that the plan be modified as I've indicated, be filed by May 28th with the hearing then on June 9th. So ordered. It'll be in front of Judge Wagner at that time. Anything further from the state?
No, thank you, Judge.
Anything further from the defense?
Just that Ms. Geyser would like to be returned to Winnebago today if possible.
I order that she be returned forthwith.
Thank you.
Thank you. I want to note that I had authorized civilian attire today.
Pardon me?
I had authorized that she could wear civilian attire.
Oh, okay.
You didn't know that?
they didn't say anything. I apologize.
Really? Well, your attorney knew it was in the court file. Well, good luck. Have a good day then, everybody. Thank you.